everyone, and we are on our 13th lesson. And before anything else, I want to say thank you to those who subscribed our YouTube channel and also followed us on Facebook. And I thank also those people who sent me private message directly to me saying that they are constantly and religiously following the lessons. And now, before we begin, actually, before we go to the substance of our lesson on last will and testament, I want to say or share to you a very personal experience. Actually, when I reached the age of 18 years old back then, I wrote on a notebook sheet the things that I wanted my family to do when I'm gone. Like in case I die because of accident, I wanted to donate all my organs that can be donated, and I wanted my clothes or my books, things like that. And I wrote it personally, and I wrote my name and even put my signature and have it dated. Then when I was in law school studying succession, and I was quite surprised that it was indeed a valid holographic will. And in this lesson, you will find out what is a holographic will. And actually, when I found it out, I was really like quite surprised. And I mean, like, I told myself, like, now I know the legal consequences of that simple act. And to me, it's really worth studying the law. Now we begin with the nature and characteristics of a last will and testament, or shortly known as a will. It is a document executed by a person who is called a testator, and it determines the disposition of his estate upon his death. But you have to remember that it can be confirmed or affirmed by the testator even during his death by filing a petition before the court, and I will tell you later in the second part of the lesson. And it can include the last wishes of the testator, meaning if he wanted to be cremated or he wanted to be buried in this cemetery. Now, it should be written and not in any other form, because the law requires that it should be in writing. And even if other jurisdictions would allow audio or video recording, still the Philippine laws will apply, especially to those Filipino nationals. Now, it can be done also with or without the help of a lawyer. So, as I mentioned in the onset, that I made my own holographic will at the age of 18, and I did that without the aid of a lawyer. Now, among the characteristics of a last will and testament is that it is executed by a person not expressly prohibited by law to do that, and he must be 18 years old with a sound mind at the time of the execution, meaning that the person may be insane or declared to be insane previously, and now he is under lucid interval, and at the time of the execution he is considered to be of sound mind, then that last will may be given effect. Then you have to also think that even deafness and blindness is not even a hindrance for a person to execute a will. Now, if there is property involved, the disposition must still conform to what the law provides. What I mean by this is that the legitimes of the compulsory heirs must not be affected unless there is a valid ground to disinherit that person. And it would relate to our last characteristic that I listed here, that the last will should not be used to disinherit the compulsory heirs without any legal basis. And rest assured that in later lessons in the future, we will be including the legal basis of disinheriting a compulsory heir. And as I mentioned a while ago, the person must be of sound mind at the time of the execution of the will. And the law provides that it is sufficient that a testator must be able to know the following. First, the nature of the estate and the proper objects of his bounty, meaning the coverage or the listing of his properties, whether it is real or personal property. And third, the character or the characteristics or character of the testamentary act, whether it be a notarial will or a holographic will, and he must know the legal consequences of that. Now, the applicable laws, because I was talking a while ago that the law requires this and that. So, what are the applicable laws? Actually, it is Book 3, Title 4, Chapter 2, Section 1 of the New Civil Code, and that covers Articles 783 to Article 839, and it talks, among others, the testamentary capacity and intent, and um, forms of wills, and even probate of wills, and invalid wills also. And one of the applicable laws would be the rules of court, because the new civil code provides that probate of a will must conform to the procedure as established in the rules of court. Now, among others, laws that would be also applicable to last will and testament is the national law of the testator, in case foreigners who sojourn here in the Philippines executed a will for themselves, and then the law of the nation, the law of which the foreigner is a national shall be applicable. And of course, in the later future, again, we will have the conflicts of law lessons, and that would include the execution of wills by Filipinos abroad or by foreigners in the Philippines. Now, who are the persons involved before we end this first part of the lesson? Since there are two types of will, the persons involved would also vary. In the second part of the lesson, we will give you the specifics of a notarial will and a holographic will as prescribed or as established by the new civil code. Now, a notarial will requires the testator, the witnesses, and the notary public, because it is, as according to its name, is a notarial will, and that needs the notarial act of the notary public. Now, on the part of the holographic will, it is only the testator that is included or required under the law. So, I hope in this very, very short part of the lesson, you know something already, and you will look forward to the classifications of wills, the specific requirements of each will, and also the disqualifications of witnesses, because that will be included later. Thank you so much. Thank you, and you take care.